Ron Carlson, a professor at the University of Georgia School of Law, says that the 21 states that have co-signed on a brief attacking the health care reform bill have made a step in the right direction in getting what they want.
That's a pretty daunting attack. 21 states joining in with their attorney generals to say this is unconstitutional legislation.
The senators have filed their amicus brief, or a friend of the court brief, with Florida U.S. District Court Judge Robert Vincent.
Before a judge who is felt to be somewhat sympathetic to their position, who is hostile to Obamacare.
The federal court challenge focuses on the constitutional concerns over the requirement to purchase health care insurance and punishment for not purchasing that insurance. Although this amicus brief has been filed in a Florida U.S. District Court, it is likely just the first step to get this ball rolling so that the case eventually reaches a U.S. Court of Appeals in the 11th Circuit and then goes on to the U.S. Supreme Court. Carlson says that once it reaches the Supreme Court, the final decision will likely be left up to the swing vote by Justice Anthony Kennedy.
Well, one thing we can be pretty sure of, it will probably be a 5-4 decision.
The amicus brief addresses 2 points. One deals with the nation's Commerce Clause.
That's what the Obamacare legislation hangs its hat on. Congress's power to regulate interstate commerce. The problem is, very little doctor-to-patient interchange occurs interstate.
Secondly, the brief states that the individual mandate that everyone purchase health care by 2014 is unprecedented.
The senators say, never before in the history of this country has the federal government mandated that an individual citizen must buy a private product.
Carlson says that whatever the courts decide, it will be done before 2014 when the law takes effect. In Athens, Amelia Hines, WNEG News, Northeast Georgia.